International Humanitarian Laws and Refugee Laws organized by Institute of Law, Nirma University. Today, we have all gathered here to discuss and deliberate upon questions which are integral to the human race. International humanitarian law and refugee laws are complementary bodies of law that share a common goal: the protection of lives, health, and dignity of persons. They form a complex network of intersections so as to encourage a democratic state setup and affirming positive state obligations. It is a matter of immense pleasure that ILNU is hosting the 10th edition of this conference on the theme Changing Contours of International Humanitarian Law and Refugee Laws, with a number of diverse sub-themes. Institute of Law, Nirma University stands as one of the fastest emerging law schools in the country with its ever-changing pedagogy. The institute aims to add new dimensions in the world of legal education, incorporating international standards. Without further delay, I would like to request you all to bow down your heads for the prayer.
या कुन्देन्दुतुषारहारधवला या शुभ्रवस्त्रावृता या वीणावरदण्डमण्डितकरा या श्वेतपद्मासना या ब्रह्माच्युतशङ्करप्रभृतिभिः देवैः सदा वन्दिता सा मां पातु सरस्वती भगवती निःशेषजाड्यापहा.
Our panel today is made up of luminaires who are changing the world one day at a time. Their vision for a better world drives them to do exceptionally well in their respective fields, and their motivation is contagious. It is my honor to introduce them to you all. We have today Honorable Justice Ravi Kumar Tripathi, the chairperson of the Gujarat Human Rights Commission, gracing the occasion with his presence as the chief guest of the conference. Sir was a former justice of the Gujarat High Court and was appointed as the chairperson of the Gujarat Human Rights Commission in the year 2020. He has a keen academic leaning and has obtained degrees of BCom in Advanced Accountancy, MCom in Modern Business and Industry, and LLM in Public International Law, and passed the intermediate examination of the Institute of Company Secretaries of India. Sir has appeared for statutory bodies like ONGC, Mudasa Nagar Palika, Thoraji Nagar Palika, and Junagadh District Panchayat. He has practiced civil, criminal, constitutional, labor, and service matters. We are extremely fortunate to have you amongst us, sir. We welcome you. I would like to welcome our expert speaker, Honorable Justice Dr. Jyotsna Yachnik, Pro Vice Chancellor and Director, School of Law and Justice, Adamas University. She is also the former Principal Judge, City Civil and Sessions Courts, Ahmedabad, former Principal of Law College and the Director of Yagnik Law Academy, imparting education for judicial services. She is present with us as a clinical professor. We would like to thank Jyotsna ma'am for giving us her valuable time and enlightening our ceremony with her presence. Our panel of judges includes Professor Dr. Sanoj Rajan, a distinguished professor of international law and human rights at Zhejiang Gongshang University, Professor Dr. Adam D. Dubin, the Director of International Public Department at Faculty of Law, Alberto, and Professor Rajitha Nair, a doctoral candidate at Nalsar University with experience as an academician and working with civil society and research organizations. This event is presided over by Dr. Anup K. Singh, the Director General of Nirma University. Sir is an eminent academician and an excellent leader. Under his leadership since 2013, Nirma University has moved from strength to strength. He has many publications to his credit, comprising of books and research papers at both national and international radios. He is a recipient of various awards for his teaching excellence. We heartily welcome you all. We have amongst us Professor Dr. Madhuri Parekh, the Dean and Director, Institute of Law, Nirma University. Ma'am has been associated with the Institute since 2007. Her areas of interest include legal research, environmental law, and forest law. She has presented papers at various national and international conferences in India and abroad. She has also completed 2 projects funded by the Gujarat Ecological Commission on the issues related to implementation of the notification of coastal regulation zone. It is an honor to have you amongst us, ma'am. I would once again like to welcome all the dignitaries seated on the panel. It is your presence which has marked the level of expertise and excellence in this conference. Now, I would request Professor Dr. Madhuri Parekh, ma'am, to address the gathering.
Thank you, ma'am. Honorable Justice Ravi Tripathi ji, Chairperson, Human Rights Commission at state level. Honorable Ms. Jyotsna Yagnik, ma'am, Dr. Jyotsna Yagnik, ma'am. She is known for her distinguished contribution to the judgment through the judgments and many remarkable judgments. She is at present with us as a clinical professor. Dr. Anup K. Singh, Director General, Nirma University. Distinguished speakers and invited guests and the participants, and my colleague and the center head, Ms. Anviksha Pachori. I warmly welcome all of you to this 10th edition of this International Human Rights Law Conference. Almost a decade. We have been celebrating this event and organizing this event every year since last 10 years. So it gives me a pleasure to share with you that every year after the conference, we have published proceedings, and in that way we have contributed to these deliberations on human rights. There are many concerns and issues at present which we need to deliberate upon. Though we have made attempts at global level, at regional level also, to protect the rights of the vulnerable groups, maybe climate migrants, maybe rights of minority, maybe rights of women and children. And at different times, we have tried to define different generations of right. So number of attempts we have made at the national and international level, but still there are new issues and concerns which are emerging in this developed world and developing world. So this conference is very relevant for any law school, and the experts' opinion, then the deliberations in such conference, it helps us in understanding the issues related to human rights. It also develops a kind of a awareness among the students for the human rights. So this conference is very helpful for any law school, because any law school can contribute substantially in this area by following the 3-dimensional approach. One, making the students aware about the human rights, promoting the making them sensitive and sensitized to these rights. So 3-dimensional approach is required. One, teaching through human rights, teaching about human rights, and teaching for human rights. So when we talk about teaching about human rights, making them aware what human rights are. Teaching through human rights, developing that skill and engaging them in actual contribution towards the human right protection. And teaching for human rights, teaching those values for human rights. So these three things are needed. And through our syllabus, through our curriculum, we try to develop those awareness and value. But this kind of conference and interaction that takes place in the conference, it helps them in understanding the issues in a better manner and developing those values in a better manner. Because number of emerging issues will be discussed in this conference, and particularly many students are participating in this conference. That is the plus point of this conference. Since last 10 years, many students have been benefited by this. So this conference is very relevant, and I express my sincere thanks to all the dignitaries who have consented to be with us and to be part of this conference. Thank you so much. I wish all the best to the center chair and the organizing team for the successful completion of the conference and a very good proceedings as the outcome of this conference. Thank you once again and all the best.
Thank you so much, ma'am, for your kind words and support. Now, I would like to invite Ms. Anviksha Pachauri, a faculty conference coordinator of the event, to brief you all about the conference. Ma'am is the faculty coordinator for the Center of International Humanitarian Law and Human Rights at Institute of Law, Nirma University.
Thank you, Arman. Good morning, everyone, to all the dignitaries, my fellow colleagues and student. My name is Anviksha Pachauri. I'm currently heading the Center for International Humanitarian Law and Human Rights at the Institute of Law, Nirma University. Today, our center is organizing the 10th edition of its annual flagship event, that is International Virtual Conference on Changing Contours of International Humanitarian Law and Refugee Law, which is in collaboration with ICRC and United Nations High Commissioners for Refugee Law. It gives me immense pleasure that this conference will mark the completion of a decade in organizing and continuing this discourse on IHL and refugee law. In 2020, we have celebrated the 70th anniversary of Geneva Convention, and since then a lot has been changed. Now we cannot even imagine our lives without technological tools because of the advent of the COVID-19. On the same line, the means and method of warfare has also totally altered, where drones are enough to cause damage or kill the combatants, making the battlefield absolutely obsolete at this point of time. When it comes to the refugee law, in the last 5 years, we have witnessed a dramatic increase in the number of forcefully displaced people worldwide. And a key part of this international response has been a multilateral effort to develop an architecture to share responsibility for hosting and supporting the world refugees. Today, this conference will offer a reflective assessment and an academic discourse which has been achieved by these protocols and the conferences, the key milestone of which has been a New York Declaration, the Global Compact for Refugees, the first Global Refugee Forum, and access to what has been achieved and what are the challenges lie ahead. The conference will also reflect the emergence of the COVID-19 pandemic, its impact on the international refugee response regime. Looking at this ever-changing world, we have come up with some innovative themes which would aim to promote the discussion that reflect the successes and challenges on the treaty implementation, the new advancement in the field of IHL that has been universally ratified. The 6 major themes of this proposed conference is first, violation of the human rights and international humanitarian law against religious minorities. Second, the convergence of armed conflict and the effect on the environment. Third, access to healthcare for asylum seekers and undocumented people. Fourth, the potential human right at stake due to cyber operations. Fifth, world refugee crisis vis-a-vis right to self-determination. Sixth, sexual violence and inevitable aspect of war. We are glad to share that we have received paper from NLSIU, NUJS, GNLU, Jamia Millia, Jindal Global, HPNLU, ILS, SLS, and many more from the research scholar all over the world. We are really looking forward to academic discourse and presentation of the participants in the plenary round, which will happen right after the inaugural. Thank you so much for joining us. Thank you.
Thank you so much, ma'am, for your insights. It is now time to release the conference proceedings of the 9th ILNU National Students' Conference on International Humanitarian Law and Refugee Laws. If I could please request our chief guest, Honorable Justice Ravi Kumar Tripathi, to do the honors. Thank you so much. Moving on, it is indeed my pleasure to invite our chief guest of the event, Honorable Justice Ravi Kumar Tripathi, sir, to address the gathering.
Good morning to everybody. I'm really happy that even in these tough days of COVID, the Nirma Institute, the Nirma Law Institute is uninterruptedly proceeding with its activities, especially when this is told that this is the 10th International Human Rights Conference. And one thing is very certain. When it comes to talk about the human rights, possibly refugees are the first person whom we think about, because as such, human rights are available to every human being, and any slightest violation is violation of human rights of that person. But then refugees is a particular class by themselves. And for them, well, the things are very dark. It's good that with the awareness of the problem, the people do come forward and try to help these people, be it Rohingya Muslims or be it other parts of the world, the different communities which are having this particular problem. The difficulty is that when we talk about the refugees, it is definitely a social problem rather than a legal problem. And therefore, any other social problem is to be dealt by the law. This particular problem is also required to be dealt by the law, and that is why this type of conference and deliberations on the subject. Friends, it is very difficult to think about the person and his plight when he is in such a state, when there is no country of his, he is just uprooted from the place where he was residing for all these years, and then he is left nowhere and left at the mercy of the people around. So this is something very serious, and especially when we talk about the human rights, I think it's an area where the maximum things are required to be done. What I feel is that with the advance of the technology, the problems are getting graver. As she rightly referred, that drone is one which was not known so far. And this year, if you remember, the 26th January, the special performance of the drones was displayed with to the people and the country at large, is going to show that what is going to be the role of drones in so many areas of pertaining to human life. In such situation, I think we'll have to go back to the philosophy which was propounded by our father of nation, Mahatma Gandhi ji. Until you are able to control the greed of the people, it is not going to have any solution to these problems. And these problems, they cannot be tackled by mathematical formulas like 2 + 2 is going to 4. This is not the problem of that nature. And therefore, it has various different facets. And those facets are required to be dealt by the sociologist on one hand, the psychologist on the other, the other branches of human sciences. They'll all have to put their heads together. And then only this type of problem can be solved. Humanitarian law is very, very nice sounding word. But then when it comes to implement, like international law, when we talk about, the first and foremost thing which is missing about the international law is there is no sanction behind that international law. Now, if international law does not have any sanction, more comes about the international humanitarian laws, which also do not have any sanction. The only sanction with the like-minded people is to see that the country which is violating or creating that particular problem is put under the economic sanctions. And in this changing world, only military operations are not enough. If you know, Ukraine problem is going on, and every day we hear news that possibly tomorrow is the day when the war will break out. But it's not that easy that it will break out, because if the war breaks out, it will have, tremendous repercussion on the human race as a whole. Any use of any atomic weapon is not going to restrict its effect or bad effects only to that particular area. They are going to spread over, and that is going to affect the entire human race. In such situation, if you have heard further about that Ukraine problem, even Russia, like country like Russia, is also under some constraint of going to the war, only because there are economic sanctions against him, because its relations with the European countries, especially the economic relations, they are at stake. So these particular problems are having a manifold dimension, and all these dimensions can be noted down, can be listed down with the deliberations like this in this type of conferences, and then it is ultimately to be handed over to the young generation which is coming forward. And it will be for the young generation to see that the problem is solved with a very different approach. You cannot solve any problem of refugees or humanitarian law by only a technical approach or a stricto sensu legal approach. Because stricto sensu legal approach is never, even in our civil courts, the stricto sensu legal approach is never working. It has to be, the honorable judge has to be cautious about, has to be conscious about the other facets of that particular problem. If you remember, the family courts especially, where the judge is supposed to not only look at the law, but is supposed to look at the humanitarian aspect of that particular problem and try to find out a solution to that particular problem, and a solution of such nature which should have an everlasting effect. It is easy for passing an order that all right, so and so is asked to have the restitution of conjugal rights or anything, but then that is not the law which is going to have its everlasting effect until the parties are made ready to accept that particular legal judgment or law judgment. So what I feel is that this is a very good exercise the Nirva Institute is undertaking, especially Ms. Pachauri, the center which has worked for all these years, and especially when you are having this all documented proceedings of such conferences, it is going to be a good material for the further studies and deeper studies of these problems. And be it any convention, be it Geneva Convention or any other convention, until the willing parties are having their readiness to follow that particular convention, all those conventions are going to be only on paper. And the best way of getting those conventions implemented is the economic sanctions against the erring party or erring country when it comes to implement those particular humanitarian laws or refugee laws. Friends, refugees, as the moment you hear the word refugee, it is very difficult to entire, scope may not come to your mind. But if you want to have the real look at the problem, you visit Delhi, and especially those refugee settlements where people are there for about 35, 40 years. And generations have changed in that particular one. So they are the refugee in their own country. We are talking about the international humanitarian laws and all that, but we have a problem of refugees in our own country. And those problems are to be solved not by specific law. It has to be, the solution has to be socio-economic and the humanitarian approach in that, then only this particular problem can be solved. So friends, I wish all the success to this particular seminar. We have many more London speakers to hear and get ourselves engaged with that. I wish all the success and my regards to everybody. Thank you very much.
Thank you so much, sir. You're right. The plight of refugees is real, and we are honored to hear from you. I would now like to invite the expert speaker for the conference, Honorable Justice Dr. Jyotsna Yaknik, to address the gathering. Ma'am,
yes. Honorable Mr. Justice Ravi R. Tripathi, formal Judge, High Court of Gujarat, and as on today, chairperson, a very, very great and efficient chairperson of Human Rights Commission at the state of Gujarat. He has many feathers in his cap, but I cannot count all the feather here. So the only thing is that it was great hearing from him after long. Respected Dr. Anup Singh, my dear friend, Dean, School of Law, Dr. Madhuri Parikh, all other esteemed faculty members, and dear students. It's indeed a matter of great pleasure to share here in this international conference some aspects related to role of judiciary. I have been requested to speak on role of judiciary in maintaining human rights, and therefore I shall confine to that particular subject. If we go to the history of human rights, we are aware that it backs for centuries together, maybe 5,000 years and more, because India, Greek, etc. are the culture where there were spices of human rights. However, before 2,500 years, for the first time, Cyrus Cylinder came to the light, and it is the first charter of human rights, and that is counted as the first and noted history as far as human rights are concerned. I am very happy to say that before that also natural law did exist. Almost in all civilized countries, it was existing. It was working very well, but it does not have a form of enactment, and therefore perhaps it has not said to be a milestone of the human right. Over and about natural law, we know that in 12th century, there was Magna Carta, there was Bill of Rights, French Declaration of Right of Man, and lastly, after Second World War, UDH, or Universal Declaration of Human Rights, the aim of which was just society. When it came as an aim of just society, it is important that it has given us the watchword that all human beings are born free and equal in dignity. From that, it has been emerged that human dignity is one of the most important aspects to be taken care. Then after numerous national, international, and between two states, covenants and conventions have been executed. Many of the international covenant and conventions are related to human rights, and many of them have been signed and ratified by India and are effectively in operation in India. Many of the conventions are mainly for the oppressed class of the society, for women, for children, for prisoners, for under trial prisoners, for accused, and for many more things, more particularly concerned and connected with civil liberties, freedoms, dignity, and so on and so forth. It is aptly said that treat people like human beings and you will get human beings. The simple and easy way which has been shown. And therefore, after Second World War, a new kind of ideology came that says that इंसान से इंसान का हो भाईचारा, यही पैगाम हमारा, नए जगत में हुआ पुराना ऊंच नीच का रिश्ता, सबको मिले मेहनत के मुताबिक अपना अपना हिस्सा. And that ideology slowly and gradually has developed. But a notable point over here in this international conference, which needs our attention, is that report of Amnesty International, which is worth quoting. It has said that there are many countries in the world where there is violation of human rights. They have noted that there are 81 countries where human beings are subjected to physical torture. 54 countries where people are struggling to save themselves from unfair trials. 77 countries where freedom of expression is mockery. Freedom of press is question mark in many of the countries. It is also said that in many of underdeveloped countries, 30 to 50% of its population is marginalized due to poverty. 40% of the children are undernourished. In India also, as we know, Khap Panchayat are taking pride in breaking law, in doing express miscarriage of justice on the name of custom and culture. Honor killing has become very common. People take pride in doing honor killing, forgetting that it is clear violation of human rights. Under this background, what I have discussed, I understand, and in my humble opinion, judges have very important role to be performed in maintaining human rights and civil liberties, not only in India, throughout the world. It is very essential. The first and foremost point which comes to my mind is that every judge is required to remember the keywords of justice. The keywords of justice are equality, dignity, and equity. It is said that, after all, justice does mean a one principal keyword, and that is deciding norms of conduct. It is the human conduct which is in center where any kind of adjudication is being done. The modern way of judging is said to be looking to constitutional value, looking to equity, spirit of international covenants, and moreover, looking to the very basic background, sociological aspect of a particular country where justice is to be administered. It is fitting here to refer that section 2 into bracket D of Human Rights Act 1993 has said that what is human right? Human right is all rights which are emerging from life, liberty, dignity, and equality. It is all rights which are guaranteed in Constitution of India. Over and above that, it is important that it is all rights which are emerging for international covenants applicable in Indian courts. Therefore, keeping this in mind, the very basic function, the very paramount duty of every judge is to see that discrimination under any name, of any nature, of any kind, has to be eliminated. A specific efforts will have to be done. You call it gender justice, you call it justice for children, you call it justice for accused, you call it justice for victims, you give it any name. But ultimately, one has to see to it that discrimination of every nature is thoroughly eliminated. Justice is not only what said by law. Justice is also not only what is said by Constitution of India, but it is spirit of human values. It is spirit of freedom, equality, dignity, fairness, and equity. Fairness, as has been rightly said in administrative law, it requires that every applicant is required to be informed about the reasons as to why his application or why his request has been rejected or why it has been granted. Reason ordered is said to be heart of every judgment, and therefore it is essential that there has to be thorough application of mind in order to ensure that the reasons are written so properly, so effectively, that even the defeating party does carry a satisfaction of he having been heard. So right to be heard is one of the most important right which has a direct connection with human right. Adjudication is what? It is processed by the judges because judges give meaning to laws. They give words effect to procedure, which has a lubricating effect. They give ethical values to their thoughts, to their views, colored with law and constitution of India. Moral values are not being kept aside. Constitutional values are always in foundation. Social values, sense of social justice, equity, equality, fairness, all that what I have said, coupled with the paramount duty to see to it that subsistence of rule of law is not compromised at all at any cost. At this juncture, there are many courts, right from trial court to Supreme Court. Everyone has made effort, but I would only refer 4 to 5 examples of the judgment given by the Supreme Court, which have changed entire direction of criminal law, and it has given full color of human right to the whole jurisprudence related to criminal law. Sila Barse is one important famous judgment wherein the norms to be observed by the judge while the accused is produced or while the person who is arrested is produced before the respective judge. There are many more cases wherein Supreme Court has specifically said that courts are custodian and guardian of every fundamental right of every person is having. Hussain Ara Khatun, well known for speedy justice, connected directly with Article 21 of Constitution of India, it being an integral part of the concept of speedy justice, which is a part and parcel of not only fundamental right, but part and parcel of human right as well. The case of Francis Moulin is also very, very popular. It says that human dignity is the heart of Article 21, and it cannot be confined merely to animal existence. I cannot forget Sakshi versus Union of India. A litigation came to be filed by Sakshi, the NGO which is working for women and children, and the norms which have been settled, which have been propounded by Honorable Supreme Court of India, directing all judges in India to observe when a child comes to the court as a witness. All those norms into inverted comma have been imbibed, have been inserted, have been provided by way of POXO. Those who have enacted POXO, those who have written, have not to find out a single word from anywhere else. If you read Sakshi versus Union of India, you will see that the act is replica of whatever directions were given by Honorable Supreme Court. Joginder's case is related to giving information to relatives whenever anyone is arrested. Sunil Batra and other judgments well known on the guidelines of not to do handcuffing, not to hurt or not to violate human right of even under trial prisoner, taking care of their health, giving all human treatment to them, maintaining their dignity. The judgment about the fetters, that is also very important. Bantam has said that witnesses are ears and eyes of judges. When they are ears and eyes of judges, I must say that they must be protected. And I am very proud to state for and on behalf of Indian judiciary that we have many, many norms having been laid down by which they are fully protected. Not only that, that there is a law to the effect that no witness can be asked any question which is annoying, insulting, humiliating, belittling, or indecent in any manner, and unnecessary questions are absolutely prohibited. Though we do not have express witness protection schemes, but there are judgments wherein Supreme Courts have given guideline how and when they are to be protected in many sensitive matters. By delivering judgment, Supreme Court has given guideline to the respective state governments to see to it that the witnesses of a particular sensitive cases are being properly protected. We need to provide very comfortable and suitable waiting places in the courthouses, which we are lacking today. But I hope and look forward that it will be done in a very short period from now. Positive and supportive atmosphere, it does exist, and but it requires to be given to extendedly to many other persons who are coming to court and who are assisting the court in administration of justice. Effective and result orienting ADR, that is also missing. That is alternative dispute resolution. When Honorable Mr. Justice Tripathi was heading as the executive chairman of the Gujarat State Legal Services Authority, we had many opportunity to do many sensitive programs related to alternative dispute resolution. But those kind of program has to ongo with a great zeal. And if that is done, I look forward a day when things will be in a right place, in a right perspective. Concept of victimology, assuring fair trials are all the things which are required to be taken care by judges. Most of the things are being taken care of, but we cannot be a person to do all the while self appreciation. Yes, we lack at many places. We have poor infrastructure, we have lack of judges. The ratio of our judges is not meeting with the population we have in our India. And I think in a short time from now, even that lacuna will also be covered up. If that is being done, one big feather, a golden feather, will be added to our cap called justice delivery system. Right of an individual have though not been properly taken care of, absolutely in all cases, but attempts are sincere. We are very religiously trying to do that, and people do feel that in spite of there is shortage of judges, best efforts are being done. With this background, I wanted to say there is a big role for judiciary to perform in maintaining human rights. Some of them is being performed satisfactorily. Some of them we have yet to learn from different countries where justice delivery system is illustrative one. But we have also to say that they have better infrastructure. But we cannot escape from our liability saying that this is lacking. Whatever is lacking, our efforts are very important. And I can only end with a hope that things would be all right. It will fall in its place at right time. वो सुबह कभी तो आएगी, वो सुबह का इंतजार कर. That's my prayer to Almighty. Thank you very much to the organizer for having given me this wonderful opportunity. I have thoroughly enjoyed saying on my thoughts about duty or role of judges or role of judiciary in maintaining human rights. Thank you so much. My special thanks are due to Honorable Mr. Justice Tripathi and to Dr. Anup Singh. Thank you so much. Thank you, everyone.
Thank you so much, ma'am. I would now like to invite Dr. Anup K. Singh, the Director General of Nirma University, to address the gathering.
Honorable Mr. Justice Tripathi ji, Honorable Justice Yagnik, Madhuri Ben, participants, and dear students. First of all, I'd like to congratulate the Institute of Law for organizing such a relevant conference. As we are progressing in the 21st century, the importance of human rights is increasing. However, as Mr. Justice Tripathi was telling, the problem is somewhere else. The outer side is law, but inner side is society and human mind. So unless we recognize the value of humanity, it is very difficult to defend human rights, right? And therefore, my message to all participants and students is that we also need to understand that why we have evolved such societies where we are unable to respect human rights, why we are not able to educate our young people so that they are beyond stereotypes and prejudice, why we are not able to develop a system where we are very caring and moral towards our own groups, but those groups which are dissimilar, we are so inhuman and so cruel to them. So there is a much bigger problem, right? So along with law aspect, I think there should also be discussion about the societal aspect of the problem and the educational aspect of the problem. So along with law, when we are able to address the psychological aspect and sociological aspect, we would be able to come out with the better solutions. So once again, I wish all the very best for the success of the conference. Thank you very much.
Thank you, sir.
Thank you so much, sir. I'm sure each one of us here is delighted to hear and learn and be in the presence of our esteemed guests. Before we proceed to the sessions, I would like to invite our student chairperson, Mr. Vaibhav Mani Tripathi, to propose a vote of thanks. He is currently a final year law student at ILNU, having keen interest in constitutional law and human rights law.
Hello. Thank you, Herman. Good morning to all who have gathered here for the 10th International Virtual Conference on International Humanitarian Law and Refugee Law, organized by Institute of Law, Nirma University in association with ICRC and UNHCR. This year had its own share of challenges as we kept juggling between the offline and online mode. And hence, I am immensely grateful to everyone whose support and guidance has made this conference possible. In this regard, I would like to thank our Chief Guest, Honorable Justice Ravi Kumar Tripathi, sir, for gracing us this conference with his auspicious presence. I would also like to thank Honorable Dr. Jyotsna Yagnik, ma'am, for giving us her valuable time and helping us gain insight regarding the contours of the subject. I would also like to thank Dr. Anup K. Singh, sir, Director General, Nirma University. Further, I extend my heartfelt gratitude towards our panel of judges who have joined in from different corners of the world. So thank you, Professor Dr. Sanoj Rajan, Professor Dr. Adam D. Tubin, and Professor Dr. Rajita Nair. I would like to thank Professor Dr. Madhuri Parikh, Dean and Director, Institute of Law, Nirma University, and our faculty coordinator, Anviksha ma'am, who were there to guide me and the team at every step. Sincere grateful thanks to the student section who ensured that the conference is run in a smooth manner. So thank you, Ramesh sir, Digant sir. I would also like to thank participants who have showed immense interest in joining us in this conference. I'm glad to inform that we received around more than 60 applications for the conference from around 5 countries and across different universities from India itself. Last but not the least, I would like to thank my team that stood resolutely behind me. In this regard, I would like to thank Harmanjot Kaur, Secretary for the Center, Shambhavi Gautam, the Treasurer, and other core members and volunteers. Thank you so much.
Thank you so much. With this, we come to an end of the inaugural session. We start our plenary sessions at 11. And I would like to thank all of you for making it possible to join us and grace the occasion with your presence.
Thank you. Thank you, Ravi sir. Thank you, Atma.
Thank you so much.
Thank you, Anup sir.